Hi, I'm Janice Switlo. In 1651, Leviathan was published. That's the written by Thomas Hobbes, who lived 1588 to 1679. And in this, he said, you know, the life of man without law, and he's a philosopher and writer, the life of man without law is, quote, solitary, poor, nasty, brutish, and short. Now, in the trial decision of Delgamutte, Justice McEachern quoted that section, you know, nasty, brutish, and short. What he was actually saying by doing so, and a lot of people, you know, say, well, that's not, you know, true. We lived long and things like that, but they were really missing the point of what he was saying. And he was saying, and reaffirming the doctrine of discovery, for example, to saying that these people at contact, they had no law. And that's what justifies then Canada creating this new Section 35 doctrine, because of course that Delgamutte process that further, started with Sparrow decision, but got further developed under Delgamutte as it proceeded to the Supreme Court of Canada. So it's really important to understand the premise that Section 35 is based on. Okay, that's a finding, you know, that's a statement of fact, a trial, and it was not specifically overturned, if you will. And the Supreme Court of Canada ultimately just sent the whole thing back to trial. It became an issue of how big a piece of land should we say an Aboriginal right of Aboriginal title applies to under the doctrine. Now, it doesn't deal with this concept, and we're still dealing with this today, right? We have at Wasudaton that consent is being ignored by those who exercise authorities on their land. In BC, and again, Delgamutte comes from BC, right? And it happens to be the very same people. The perspective is that, well, they had no law. Well, if you have no law, it's anarchy. You really are just truly beasts of the field. There's no organized society. There's, you know, all that other stuff. It's not true. And unfortunately, that perspective, that just because Indigenous nationals lived in a manner that was not familiar to Western societies, for example, does not mean that they were lawless. So this is critical to not only speak of ownership of land and our land, you know, the land of our children and grandchildren, but equally important to say we're here because of the very fact that we do have laws, and we continue to have those laws, and there is at absolutely no point were those ever abandoned. They were never given up through treaties. In fact, the confirmation that there are nations, all nations have laws. These are human beings. All human beings consist in societies and communities and have laws. To suggest that this was not the case for this particular area of the world, where occupied by certain and owned by certain human beings that look a little different and practice a different religion or different spirituality, is not good enough to say, well, that means they had no law. They do, and that law is recognized internationally, provided that it's not abandoned. And it can be easily abandoned, as I've said, by using terminology that says we're underneath Canada. If you're underneath Canada, you don't have your laws. If you sign off on the Anishinaabe Nation Governance Agreement, you have no laws. You're being incorporated, and your laws are as a company that's governed by Canadian jurisdiction. You can't have your own laws as a original entity, as the original nation, by doing that. That's all I have to say.